Welcome to the Tenant Law Podcast, where all types of New York City tenants can learn about the laws that affect their apartments. Rent-stabilized tenants, free market tenants, good cause tenants, luxury tenants, loft law tenants, co-op shareholders, subletters, roommates, co-livers. Let's all learn to live better. Welcome to the Tenant Law Podcast, where we talk about new, interesting, and/or important legal cases affecting New York City tenants. First, we give you some background so you have the context to understand the case we are discussing. Then we talk about the case itself, and finally we explain why the case is important and give you our tenant takeaway. I am Michelle Itkowitz, and today's case is a fairly recent Bronx housing court case. First, let's set the stage with some context. There are protections in place on the city, state, and federal level to help prevent people who are the victims of domestic violence and experiences similar to domestic violence from being evicted solely as a result of those experiences. In New York City, we have the New York City Human Rights Law that prohibits discrimination in housing based on actual or perceived status as the victim of domestic violence, stalking, and sex offenses. Now, that law is important because it will not only protect you against eviction, which is the main topic of today's podcast, but it will also protect you from a landlord or broker or agents treating you any differently because of your experiences as a victim or survivor. For example, they can't refuse to rent to you because you have an order of protection against a former spouse, and they can't refuse to accept government rental assistance regularly provided to victims and survivors of domestic violence because they fear that you or your family will create a nuisance in the building. Then on the state level, in New York State since 2016, we have two laws that work together to prohibit eviction based solely on domestic violence victim status. And the one in the case today that we're talking about is Real Property Actions and Proceedings Law, Section 744. Two things about the state law. These laws create a presumption that prevents eviction, but the landlord can rebut that presumption. So in other words, if a landlord can show that there are other valid reasons for the eviction can still happen. And this state law doesn't apply to two-family homes where the landlord is living in the home. And then, if you're receiving a federal rent subsidy like Section 8, you might also be protected by the Federal Violence Against Women Act. Two things about the Violence Against Women Act. First, it does not only protect women, it protects everybody. And second, in fact, a Section 8 landlord cannot even start an eviction proceeding against anybody unless they include a special Violence Against Women Act notice as part of the eviction papers. Interestingly, there are not a lot of published housing cases in New York on the topic of domestic violence and evictions, but I have a very important and very new one for you today, so let's get into today's case. In today's case, the landlord attempted to evict the tenant who had lived in the apartment for 30 years based on nuisances that interfered allegedly with other tenants and the building employees' safety and quiet enjoyment of the building. The nuisance behavior was all ascribed to the tenant's adult son who had moved out. One of the allegations in the court papers was that the son held the mother hostage in her apartment, necessitating an NYPD SWAT team to be called. Tenant's lawyer subpoenaed all the police records about the bad acts of the son against the tenant, the mother. 9 incidents of domestic violence and a bunch of orders of protection came as a result of the subpoena. The 9 incidents were violent and pretty horrific, and I'm not going to repeat them here. By the way, I'm not telling you the name of the case, although it's in the show notes with a link to it, because it's bad enough that this tenant had to live through this. I don't need to put her on the internet in this way. The son was 26 years old, and the case mentions that he was off some type of medication and may have needed to be hospitalized. It also describes him as a drug user and a person experiencing homelessness. The landlord claimed that it was bringing the case to protect the other tenants from the son. The tenant's lawyer's position was that all of the behavior described in the termination notice was the son's bad acts toward his mother, the tenant, not toward other tenants of the building or building employees. The judge seems to have thought hard about it and found for the tenant holding, and now I'm kind of paraphrasing from the case. The termination notice relies on incidents arising from the domestic violence perpetrated by the son against the tenant. There is no denying that but for these incidents of domestic violence, there would be no cause to remove tenant from possession of the apartment. Landlord attempts to cast doubt on whether respondent is protected from eviction by RPAPL Section 744, citing the alleged danger posed by her son to the other tenants of the building. However, landlord submits no evidence of any actual injury to its tenants or staff, no police reports, no affidavit of tenants or staff. Indeed, the predicate termination notice paraphrases many of the incidents of domestic abuse by the son against the tenant, and the police response to those incidents of domestic violence and uses this as grounds for tenant's eviction. Tenant is the victim of domestic violence at the hands of her son. Accordingly, tenant is entitled to domestic victim status. The sole basis of the commencement of this summary holdover proceeding is the domestic violence and its alleged effects on tenants and workers at the building. However, other than reiterating the abusive conduct of the son, there's nothing in the pleadings and no evidence submitted by the landlord in the form of affidavits, documentary evidence, or otherwise to establish that the conduct of the son affected anyone except the tenant, or that this conduct could be imputed to the tenant to constitute a lawful ground for her eviction. And then the judge goes on to say, and she's citing from another case approvingly, RPAPL 744 has made landlords assume the risk of financial burdens stemming from domestic violence issues rather than forcing a victim out of her home for reasons having to do with her abuse. When a statute crafts a balance between victims and landlords' economic rights, the balance set by the legislature should be strictly honored by a court. This gives rise to some very interesting tenant takeaways. Let's get the housekeeping out of the way. This is not legal advice. I am not your lawyer, but because I am a lawyer, this might be considered legal advertising. If it's legal advertising, it is terrible, because I am asking you not to contact me. This pod is not a commercial for me or my law firm. This is simply the podcast that I always wanted to make. Let us know what topics you would like to hear more about. If you like our work, please give us those 5 stars and put this podcast on your socials. It's time for the tenant takeaway. Tenant takeaway time. It's interesting to me that in my 30-year career, I have often enough bumped into people new to the multifamily real estate investment space. It's usually people coming from other industries who think real estate is an easy investment, as if you buy the buildings and they just start magically sending you money. Managing multifamily real estate is a job. It's a career, it's a profession, and like any other profession, there are professionals that take their work seriously and run great buildings, and then there are people who just never seem to embrace how much hard work running a building is. Why am I telling this to a tenant audience? Well, for one thing, I think one of my strengths is I understand what everyone out there is up to, and those insights can be valuable. I tell landlords that multifamily buildings contain humans, and humans come with problems. So yes, your tenants' problems become your problems to a certain extent. And unfortunately, we live packed in a city of almost 9 million people, and our neighbors' problems can become our problems as well. This case is a stark example of our court system attempting to navigate the difficult balance between the rights of this 30-year tenant who's obviously suffering mightily with her mentally ill adult child and the rights of everyone else in the building and the owner. And that's just not easy. And it's not going to become any easier as the vacancy rate continues to shrink and mental health problems continue to expand. I looked at a New York State Comptroller report from October 2023. It says that in 2022 in New York City, 40,000 people. 40,000 people, almost, were the victims of domestic violence. And that's an increase of 12% over 2021. I just wonder, it's my podcast, I'll wonder if I want to. I wonder, could the landlord have approached this differently? The tenant is there for 30 years. This guy that is causing all the problems grew up in that apartment. He's not there anymore, but he grew up there. Does the building community owe these people nothing? Could the landlord work with this tenant in some way to try to keep the abuser out of the building? Could they beef up security? Could they move her and her tenancy rights to another unit within the same building? Maybe that would help. I don't know. I'm not claiming to have the answers to all the world's problems because I have a podcast. We're just looking at some interesting cases because the law belongs to you. I put a link in the show notes for contacting the Law Enforcement Bureau of the New York City Commission on Human Rights to file a complaint if you believe you have been the victim of housing discrimination based on your status as a victim of domestic violence. And I also linked to a pamphlet that the Human Rights Commission puts out. The New York City human rights law requires that the complaint be filed within 1 year from the date of the last alleged act of discrimination. And there you have it. Remember, New York City, the law belongs to you, but your ownership of the law is only as great as your understanding of the law. So let's learn to live better. I am Michelle Itkowitz, and this is the Tenant Law Podcast.